Good morning, John. Welcome on. I'm just touching base with the other plenary experts and getting the questions ready, but we're excited to have you with us this morning.
I lost the number of the other guy.
Okay, so did you reach David?
No, where that screen went away after I called Sweat.
Okay. Hi there. We're just getting the last plenary expert on, and then we'll be ready to start, Sweta and
Hi.
John. Thanks so much.
Sure.
What you need, more cover?
I'm not sure if this is working. Yeah, that's okay. So let me switch it to the other one. Hi there. We're just getting ready. So there's one more plenary expert who's going to be joining us, and then we should be ready to start.
Sounds good.
Excellent. And John, can you hear me well?
Yes, you're coming through on the recording.
I'm speaking to John on the plenary as the expert.
Yeah.
Great. And John, you'll turn back on the video when we get started officially?
Okay, I just left it to keep you seeing my cats running around.
Got it. Did you call David?
I did. That's great. You got what you need. You got the link.
John, did you reach David? Great. Great. So we just confirmed the other plenary expert will be joining momentarily, and then we'll be able to get started in just a couple minutes. Thanks so much. Great. So we have all the experts ready. We have almost all of the questions. We're waiting on the last group to finish their last questions, and then we'll get started here.
Hello?
Hi there. Is
Okay.
that
All right. It's David. I'm sorry. My mute was on. I couldn't hear anything.
That's all good.
All right.
And John, you'll turn on your video as well once we get started, correct? Thank you so much.
Should be on already.
Okay.
We'll just be another minute. Hi there. So we'll get started as soon as, John, you activate your video, then I'll get started sharing the questions from the groups. We've got live viewers watching us at this point. Excellent.
Says that the video is active.
Excellent. The video is active now. It works well. We're all ready. Thank you so much. So welcome to the TechCrunch Silicon Valley Community Foundation, Knight Foundation, Miami Community Foundation, Reframe It National Online Dialogue within the tech community on immigration reform. We have multiple distinguished experts on our plenary panel this Saturday, September 6th morning. We have David Leopold, who is founder and principal of David Wolf Leopold and Associates, where he specializes in matters of immigration, visas, and citizenship. His work focuses on representation of healthcare institutions and physicians, deportation, defense, federal immigration litigation. He is an advocate for immigration reform and has served as the president of the American Immigration Lawyers Association. Thank you, David, for your participation today.
Thank you.
We have Sweta Khandelwal. Sweta Khandelwal is the principal attorney at the law office of Sweta Khandelwal, a firm specializing in U.S. immigration and nationality law. She has been recognized as one of the top 40 under 40 immigration lawyers in California by the American Society of Legal Advocates and is chair of the Silicon Valley chapter of the American Immigration Lawyers Association. In addition to Mr. Khandelwal's professional experience in the field of immigration law, her personal experiences as an immigrant to the U.S. have provided her with extensive knowledge of the challenges faced by employment-based immigrants. John Miano, thank you, Sweta, for your participation today. We're very pleased to have you with us.
Thank you. Just a small correction. I was actually chair until June. I'm no longer chair of AILA right now. So.
Thank you. Thank you. Noted. John Miano is our third plenary panelist today. Mr. Miano has been with the Center for Immigration Studies since 2008, and his area of expertise is in guest worker programs, particularly in how they affect the technology workforce. Mr. Miano has a BA in mathematics from the College of Worcester and a JD from Seton Hall University. Mr. Miano is also the founder of the Programmers Guild, an organization committed to advancing the interests of technical and professional workers. Thank you all, three of you, for participating with us today. I would like to now turn to the questions from our participants. Group 1 asked, why haven't the proponents of the e-visas publicized success stories? How can this guide legislation? Let me ask that again. Why haven't the proponents of the e-visas, the letter E, publicized success stories? How can this guide legislation? Would one of you like to take that?
I'm happy to take it. Well, I'm not sure they need to publicize it. The e-visa has been a pretty successful program. It is for those who may not know what it is, there's two visas involved. One is a investor visa, where people can invest a certain amount of money. There's no limit or no bottom to how much should be invested. It has to be funds put at risk. Or under that visa, some feedback here. I don't know whether it's.
Well, there's some feedback. Maybe if we mute those who are not speaking, John and Sweta, I'll try to make sure that everything's muted over here.
Can you hear me?
Now that's work. Now I don't seem to be seeing the feedback. So
Agreed. Yeah. All right. So basically, the e-visa is an investor or a trade visa. It depends on a treaty with various countries. It's a very my opinion as a practitioner, it's a very good visa because it allows people to invest in the country, create jobs, or to trade with the United States. Why isn't it published, or why isn't it promoted more? Probably because there's a very small number of people that qualify for that visa. Number one. Number two, that when things are good, you don't hear about it as much, and there are very few complaints with the e-visa program, other than it doesn't, in and of itself, have a pathway to citizenship. Of course, none of the non-immigrant visas, none of the temporary visas do, so that couldn't be the reason. I guess what I'm trying to say in a long-winded way is I don't know why it's not been publicized more. I know that in the Senate bill that was promoted or passed last year, there were some tweaks to the e-visa system, and I think the idea of attracting more investment by science, technology, engineering, math experts is a very good thing for the country. I think it could be held out as the shining example of why we need to be attracting more investors, more entrepreneurs, more traders to our country to create jobs and to stimulate the economy. I personally think and professionally think that it's an excellent program, and it should be touted as a success of what otherwise is a fairly dysfunctional statute, immigration law.
Thank you, David, for answering that. And let me also turn to see if John or Sweta would like to chime in, either in reaction to what David just shared or in reaction to the question that was just asked.
Yes, I'm having some disturbance here again. Okay. Yes, I would definitely agree with everything that's just been said, and I would like to add, I wish there was a between US and India and US and China, because these two countries are particular victims of the excessive backlogs. We have a huge number of entrepreneurs who really have no other way of starting businesses here, since CE does not really apply to them, and so we kind of have to try to see if the H1 works, which most often it does not. So yes, the E is definitely a success, and again, I don't see it being extended, or the treaty being extended to include India and China. I just hope it did.
Thank you, Sweta. John, would you like to react to this, and please to turn on your camera as well if you would like to respond to this one. John, we're having trouble hearing you. I can't hear you. Um, sorry for the brief pause of that. I think we're trying to figure out what the feedback is coming from. John, if you can mute your mic so that we can then go to the next question, we can try to work on addressing that to make sure that you're able to participate accordingly. Sorry for the challenge there for that moment. So let me move to the second question from Group 1. So Group 1 asked, how can tech companies justify demanding an increase in H-1Bs when there are already 2 U.S.-based STEM graduates for every U.S. STEM job? Let me ask that again. So, how can tech companies justify demanding an increase in H-1B visas when there are already 2 U.S.-based STEM graduates for every U.S. STEM job? Would one of you like to begin on that question?
Want me to start?
Yes, I think that would be great, David.
Okay, yeah, I don't mean to dominate here, but okay. So the question is why? How can they justify an increase in H-1Bs? Well, okay, I think there's a couple of reasons. First of all, the H-1B program has this arbitrary statutory caps to it that really don't have any function with the way the economy works, and it's really written. It's an arbitrary cap thrown into the law that doesn't reflect the function of the American economy. So if you look at what happened with H-1Bs, the cap is there's no more than 85,000 H-1B visas per year under the law. It's statutory cap. When the economy went bust after 2008, the demand for H-1B visas by U.S. companies went down with it substantially. That cap really wasn't as much of an issue because there was very little demand for H-1B visas. Now it was reached, but it was reached much later in the year, so there wasn't a problem. Now that the economy is back on track, we see a substantial overload in the number of H-1B visas that are needed by companies versus the number of slots. The 2-to-1 question is a question I think would have to be addressed directly to the companies. I mean, when you say STEM, generically referring to science, technology, engineering, and math, the question boils down to, when it comes to H-1B, what jobs are we talking about? Are these STEM jobs that qualify for these specific H-1B jobs? The way the law is supposed to work, U.S. workers come first. There are wage requirements. There are place, job, working condition requirements, benefit requirements, all designed to protect the U.S. worker. Now, the H-1B program clearly is not a perfect program, but there's got to be a way for employers to be able to bring in professional workers without delay, and especially in situations where there's a shortage of U.S. workers. So the 2-to-1 question, I think, is probably better addressed to the companies directly. I'd like to know where that number comes from, because certainly in many situations there are simply not enough non-citizen workers with H-1B credentials to fulfill open jobs. So I think the question could go both ways.
Thank you, David, for sharing that perspective on that question. We appreciate it. And now, I turn to either Sweta or John. Would one of you like to start next on this question?
Yes, sorry, John?
Can you hear me now?
Yes, now we can hear you.
Well, let's Sweta go first.
Okay, thank you. So again, as I said, I agree with David that I will definitely question where that particular piece of data comes from, and there is research to the contrary that indicates that actually STEM occupations have very low level of unemployment compared to the overall national unemployment rate. So I think the main question here really depends upon the viability of the data that is being coded, and particularly for STEM, like for instance, for US citizen STEM workers with PhDs, the unemployment rate, as per some of the data that I have, is only 3.15%. So the STEM fields in which a large share of workers are foreign-born in general have very low unemployment rates among native US-born workers.
Thank you, Sweta. Let me turn to John now.
Well, let me say this is somewhat near and dear to my heart because I was a computer programmer before I came to law school. And the reason why I became a lawyer is because I was working at companies like AIG and Dun & Bradstreet, and they were taking the American computer programmers they had, and they were firing them and replacing them with imported programmers on H-1B visas. So I'd be sitting in my office, and there would be an American programmer there one week, then he'd be fired, and he would have to train his replacement H-1B worker in order to collect his severance pay. So that raised the question, first for me, that was a great shock, that how is it possible for American programmers, or American workers in general, to be replaced by foreign workers? And then I started investigating this program, and I found out the H-1B program is designed to permit this kind of abuse. And in 1998, the House Judiciary Committee passed the first H-1B expansion bill, and that bill contained a short one-paragraph provision that would have banned replacing Americans with H-1B workers. And then, on the way to the House floor, this is H.R. 3736 from the 105th Congress, if you want to look it up, that bill was replaced by another bill that is 20 pages longer that replaced the provisions to protect Americans from being replaced by foreign workers with 20 pages of lobbyist-written nonsense that doesn't protect anyone. So in this legislation, it has been deliberately written to allow employers to replace Americans with foreign workers. In regard to the unemployment rates we've raised, the unemployment rate for lawyers is much lower than the unemployment rate for computer programmers and technology workers, yet there's no one who's going to argue that there's a shortage of lawyers in this country.
Can I respond to some of that, Bobby?
Sure, David.
Okay, because I didn't hear an answer to the question. I just heard a lot of political attacks. Number one, I don't doubt that John had this experience. It's an unfortunate experience, but I think the way to have gone was to the Department of Labor, which he clearly didn't do. Maybe he just doesn't know the law. Look, American companies, it doesn't make any sense what John just said, because it is expensive for American companies to hire H-1B workers. For each H-1B worker, the American company, if the company employs more than 25 workers, they have to pay a $1,500 fee plus a $500 fraud detection fee. So that's a built-in $2,000 filing fee right there, which the employee cannot pay, nor should the employee have to pay that. It's the employer's obligation. And then they have to pay a $325 filing fee on top of that. And then if they want it done within a reasonable amount of time that they can get their business going, they have to pay another $1,250. So you're talking almost $5,000 just to file it, number one. Number two, there are very serious laws in place, Department of Labor regulations, which will penalize any employer for doing just what John said they would do. Now, I would assume that John's argument here is that they're firing U.S. workers because they can hire the foreign labor cheaper. Well, if that's the case, people are going to go to prison. And people should go to prison because there are laws that require that required wages be paid, and those required wages are the higher of what we call the prevailing wage in the area of intended employment versus the actual wage paid on premises. So they have to pay the highest possible wage, and that, frankly, is to protect the U.S. worker, because if the employer is hiring a non-citizen at $5 an hour and paying the U.S. workers $2 an hour, or vice versa, paying the U.S. workers higher and paying the non-citizen lower, they have to equalize. They always have to pay the higher of the two, and that's so that they can't make it more. It can't be more palatable or more attractive to hire a non-citizen worker. And then finally, the issue of abuse being written into the law. That's always one that I hear. Let's point out that the Center for Immigration Studies is part of this network called the Tanton Network, which the Tanton Network has spawned a group called FAIR, the Federation for American Immigration Reform. The CIS, the Center for Immigration Study, is their quote-unquote think tank, and the the Federation for American Immigration Reform has been designated a hate group. So let's just see where all this is coming from. There is no abuse written into the law. The law is dysfunctional, no question, and it has to be changed. An H-1B law has to be changed. But let's just have a discussion of where we are and try to keep the anti-immigrant politics out of it. That's just my suggestion for the rest of the show.
So let me
Can I
just pause and
respond to
say
that?
everybody. Yeah, yes, but let me just say that the guiding governance of this plenary process is that I'm trying to not have this to be about any ad hominem attacks on any direction in any side. That people on this plenary have been brought together because you disagree on important public policy issues of concern to the tech community. So if we can attempt to collectively focus on the being responsive to the questions of the participants, then we'll be able to. We have a lot of live viewers watching, and so I just
Bobby,
want to be respectful.
I'm happy to do that, but I think it's important to point out what the Center for Immigration Studies is and who they are and who funds them before we continue. I'm serious. I'm very serious about that. My organization, the American Immigration Lawyers Association, and other groups that I work with, we lay bare who funds us and where we are and where we're coming from. I'm not sure we get the same from the Center for Immigration Studies, and I think we need to point that out because we've got a lot of people listening to this.
Okay, I'll let John you speak because you were spoken to directly, and then we'll turn to the next question after John.
Well, first of all, in regards to Center for Immigration Studies, I'm totally a volunteer, so I'm not getting any money here from them. The other thing I respond to is that the way the loophole that these companies use is they use a third party to supply the replacements, so that they don't have to, so that they're not paying, don't have to have the comparable wages to the workers that are actually replaced. And in the law, you can replace an American with a foreign worker at will unless four conditions are met. And those four conditions are the H-1B worker has to be paid less than $60,000 a year. The H-1B worker cannot have a master's degree or higher. The H-1B worker, the company employing the H-1B worker has to be H-1B dependent, which is more than 15% of their employees on H-1B visas, or a willful violator, and the replacement has to take place within 90 days. Now, with the current system where you're making the 90 days making the visa petition, in the current system where you're making the visa petitions in April for visas that are starting in October, that doesn't protect anyone. So thanks.
So, okay, can we, if there's more back and forth on these points, let's allow that to happen naturally in response to the other questions, because there's a number of other questions that are related to these early ones. So I'd like to proceed through our agenda, and David Sweater, feel free to chime in response to subsequent questions if you have further feedback on the discussion that we've just been having. These topics deserve a passionate discussion, so I think it's constructive that there's not a unanimous panel of experts, because that wouldn't be the goal. The goal is for diverse perspectives to be had here. So Group 2 asked the question, how are the metrics created per industry, and how do they determine the annual quotas? How are the metrics created per industry, and how do they determine the annual quotas? Sweta, would you like to start with that?
Yes, actually, I would like to know an answer to this question as to how really are they creating that annual quota. There isn't any rational basis for allotting 60,000 numbers. We really don't know where do they get this number from. Also, even at the start of the year when we are all trying to get in the line to meet, to be able to file an application in time, it's almost like you are hitting a moving target. We really don't know. Even the 60,000, the actual number of visas available is like a complex calculation. You subtract what is allotted for Chile, Singapore this year. You add what was left over from Chile, Singapore last year. Numbers which are not really released accurately for us to get an estimate of how many visas are really available. So if there really was a scientific way to decide the number of visas, or not even scientific as well as economic way of deciding what the actual number of visas should be, we would love to know. I think this is just a political number which has been increased in recent years in response to the increased availability, but for the last so many years we've just seen the number at 60. And looking by the applications that actually get in every year, 120, 130, I mean, clearly you don't need a degree in economics to say that the demand is far in excess of the supply. If you're really talking about free market economy, I don't know how they're getting this number.
Thank you, Sweta. John or David, would you like to chime in response to this question?
Bobby, the number is totally arbitrary. Like Sweta pointed out, it's a statutory number. The 85,000 is a creature of statute. So there are no metrics. It's an 85,000, and it's not by industry. It's all industries. Now, there are certain industries, or better said, there are certain companies, nonprofits that have an affiliation with a institution of higher education, certain other nonprofits or Department of Defense related institutions are not subject to any kind of quota or cap. For example, University of Michigan, Ann Arbor, since it's a public institution of higher education, would not be subject to any H-1B cap. So they could bring in as many H-1B researchers in a year as they needed, regardless of any cap. What Sweta is talking about, and I think what we're talking about here in general, are the private corporations, which are generally subject in most of the professions to it's a 65,000 person cap for bachelor level degrees, and then there's another 20,000 what we call the master's cap for master's jobs where the master's degree is from an institution of higher education in the United States. But I think the answer is that, look, this is a system that is completely dysfunctional, and it doesn't help business. And I'm talking about the H-1B program, and I'm talking also about generally the immigration statute as it's put together in general. It's unfortunate because I think there are a lot of adjustments that need to be made. And the H-1B program, it's almost like, what Churchill said about democracy. It's the worst thing except for everything else. We don't have anything else. We have other visa programs which are completely non-user friendly. Not that the H-1B program is user friendly. It's actually probably the most regulated, most difficult, most cumbersome visa for any employer to use. Requires all kinds of public notices and filings, and there's all kinds of liability attached to it. So we do need a system that is more reflective of the needs. Now, let's keep in mind that American workers do come first. American jobs come first. American technology workers and STEM graduates come first. So we do need a program that is going to protect the wages and working conditions and job opportunities of American workers. It's just unfortunate that we cannot have, we don't have a Congress that is sitting down in Washington and actually trying to solve the problem. There are some good ideas, actually, and some come from people who some of us may not expect. For example, Senator Ted Cruz. As much as I disagree with him on almost everything else he says and does and stands for, I think that he has some decent ideas on H-1B, on other technology visas. And there are some others from both sides of the parties. The problem is there doesn't seem to be any incentive, any real incentive, to get together and make this thing work for the American industry and American workers.
Thank you, David. That was clarifying, and I appreciate it. May I turn to John? Thank you.
I'll give you a short answer. The reason why we have a cap in the first place is because of the abuse that was taking place under the previous H-1 program. That Congress decided that there had to be a cap. The reason why it's arbitrary is that there's really no other way to do it other than have an arbitrary cap. I mean, if we tried to have one that's economically based, we would never, we'd always be behind the cycle. For example, Congress expanded the H-1B program in 2000, thinking there was a big boom in tech workers, and they did it right in time for the dot-com bust when we had the highest unemployment among tech workers in history. So it's always going to be an arbitrary thing.
Thank you. I appreciate the responses to that question from all sides of this, and I'd like to now turn to the second question that Group 2 has asked. Can there be a median wage that is based on employment areas and ways to anonymously report a company that is underpaying immigrant workers? Let me just phrase that one more time. Group 2 asks, can there be a median wage range that is based on employment areas and ways to anonymously report a company that is underpaying immigrant workers?
I'm happy to go.
Sure, David.
Well, the way it's set up now, I'm not sure the question. The way that the system is set up now is that there is a 4-level wage range that is applicable to any position. And so when we look at a position for H-1B, we look first of all to the what's called the ONET, the online wage online job library, if you will, for the Department of Labor. And so what we do is we tie a code from the ONET to the wage ranges of the Occupational Employment Survey, which is what the Department of Labor uses to set wages. And these are wages that the Department of Labor speculates or has concluded are prevailing in various metropolitan statistical areas. So there is a different wage range actually for every metropolitan statistical area. If I'm going to do an H-1B petition, for example, for a client in New York, let's call the position, let's say it's an anesthesiologist. So if I'm doing a wage range for an H-1B petition for an anesthesiologist in New York City, I'm going to be using a wage range which is tied specifically to the metropolitan statistical area in New York City. Similarly, if I'm going to, for that same position, the same job duties, for the same everything, minimum requirements, if the job is in Topeka, Kansas, so I'm going to be looking at a wage range for that area, for that metropolitan statistical area, and they vary. I mean, frankly, it's going to be higher in New York, obviously, as you would expect, than it would be in Topeka, Kansas. So there is a function already in place. Now, there are certain safe harbors in the statute and so on and so forth. If you really want to make sure that it's airtight and that it's not challengeable, then the method is to have the Department of Labor determine that wage. Practically speaking, that takes a long time, and the Department of Labor also uses the Occupational Employment Survey, so it's easier, frankly, to do it right from going to the Occupational Employment Survey. But I guess the answer to the question is that these ranges do exist. They do vary from area to area all over the country. So the wage in City A is not necessarily going to be the same wage in City B. Now, as far as reporting violations, the regulations and the law actually make it criminal for an employer to violate these wage ranges knowingly, and there are reporting. There is anonymous reporting. An employee can file every employer who is hiring an H-1B worker, any H-1B worker, must keep what's called a public file on that H-1B worker, which has to be made available to the Department of Labor within 3 days of a complaint filed. And there are obviously sanctions for retaliation and so on and so forth. But there are severe sanctions for failure to keep those public files, and the public files have to contain questions on data on how the wage was determined, what the wage range, how the wage was determined, what notices were filed so that U.S. workers could see the position, could see the wage that was being offered to this person. This all must be done. U.S. workers must be notified. And they must be notified not, in some picture behind the toilet where no one's going to see it in the men's room or the women's room, but in a prominent place where you'd have, for example, the workers' compensation notices, et cetera, the OSHA notices, or online if they're notifying online. So there are serious notice requirements, and there are serious penalties in the law for employers who do not follow the law or who willfully violate the law, including criminal sanctions, as there should be.
That's very helpful, David. Let me now turn to Sweta or John. Would one of you like to chime in reaction to the question? Let me just read it one more time. Can there be a median wage range that is based on employment areas and ways to anonymously report a company that is underpaying immigrant workers.
Can you hear me?
Now you're back, John. You had video for just a second there.
Can you hear me?
Yes.
Okay. Yeah, the problem that we have with the prevailing wage ranges is that Congress implemented a system in addition to geographic wages. So the law says that the H-1B worker has to be paid at least the prevailing wage for the occupation and location. But then in 2007, they required, 2004, they required the Department of Labor to provide 4 skill-based prevailing wages. And the problem is there's no real way to define what a skill is. And in setting up the 4 levels, they have the Department of Labor has set up level 3, the next to the highest, as being the average wage. So in my own examinations of labor condition applications, over half the labor condition applications are calling for the level 1 wage, which can be $20,000 to $30,000 less than the actual prevailing wage. By the time you get to level 2, 86% are at the level 2 wage, and then 95 are at the level 1, 2, or 3 wages. So 95% of the labor condition applications are calling a prevailing wage that's less than the actual median wage as the prevailing wage, and only 5% were above what would be the average wage. So yes, we need a geography-based system, but this whole skill-based system is completely nuts.
Sweta, would you like to comment on these points?
Yes, I would like to say that the skill-based system is actually defined in terms of the responsibility that the foreign national or the foreign worker assumes. The level 4 wage, which is being referred to as the median wage, is actually a level for a very senior member of the organization or the job description, someone who's assuming enormous responsibility in terms of managing a team, leading a team. So it's not just the median wage, but the skills have been pretty much clearly defined, as in what a level 1 is clearly defined as someone who who only takes instructions from his or her supervisor, does not have a say in how the job is to be performed, someone who has limited 1 or 2 years of experience, following the attainment of a degree. So it's not orbit, but the responsibilities are clearly defined. And well, question of whether how many employers select level 1 or select level 2, again, there are penalties if employers make the wrong selection. And in our personal experience as practitioners, we see that employees do complain to the Department of Labor. There are a lot of audits on the employers that are triggered on the basis of individual complaints made by employees. Many times the employees are justified, and many times the complaints are frivolous. So it's not all about the poor foreign national getting exploited because of being an H-1B worker. The reality is there is more to that.
Can I make one addition to that, Bobby?
Sure.
Yeah, just quickly. We have to also understand that the prevailing wage is just one determinant of how a wage is paid. It's not, the employer is not obligated to pay the prevailing wage. The employer is obligated to pay the higher of the prevailing wage measured against the actual wage. So what does that mean in plain English? I'm the employer. I employ engineers, right? And I'm paying my engineers the equivalent of, I'm just going to choose an arbitrary figure, $10 an hour. So that's not, it's just for purposes of illustration. So I pay my employees $10, my American employees, my average employees, $10 an hour for this job. The prevailing wage comes back at $15 an hour. So I'm underpaying my U.S. workers, which is my right to do. I'm not saying it's correct or what I should be doing, but that's what I do. It's my business. I can do what I want. But I can't pay that foreign worker what I'm paying my U.S. worker. I have to pay him or her the prevailing wage, which is $15 an hour, the higher of the two. Why is that? Why does that put pressure on me to help my American workers and raise the wages? Because I have to post that. I have to make that public to my U.S. workers. Here's what I'm paying this foreign worker. That's got to be, by the OSHA thing, and it's got to also be online. So it pushes an upward wage pressure on the employer as a disincentive to hire the H-1B worker, obviously. The flip side of that is also true. So suppose I am hiring an H-1B, and I am playing the H-1B. I offer the H-1B $15 an hour, but I'm paying my U.S. workers $20 an hour. And I think, oh, I'm going to get a good deal here. This kid is desperate, just out of school. They want a job here. I'm going to pay this person $15 an hour for the same job that I'm paying a U.S. worker. Well, I can't do that. I got to pay them the higher of the actual wage versus the prevailing wage. And in this case, the actual wage is $20 an hour. I've got to pay them $20 an hour, so I have to raise that wage. And in my experience, what happens is when the employer sees the wage, the required wage, which is what they have to pay, the higher of the two, the required wage is higher than what they want to pay or the prevailing wage or what they expect to pay, they don't hire the person or they raise the wage. So it does what it's supposed to do. Now, there are bad actor employers. There's no question about it. And those people ought to be prosecuted and ought to be brought to justice. And there are job shops out there, unfortunately, which market H-1Bs. And those people ought to be clamped down on. But for your average employer looking for a shortage occupation, the system does keep them in check if they are compliant. And most are compliant.
I'd just like to add two comments.
Yeah, John, yes, you're welcome to. Please also turn on your camera if you can.
Is it
And
not
yes,
on?
please.
You see me?
We can hear you. Not right now. We could see you before.
Sorry, I'm having all kinds of problems. The short question,
That works. Now we can see you. That's terrific.
one is that the problem was the wage levels are determined statistically. There's no data that a person of this skill makes this much money. It's derived entirely statistically. And the other problem we have is that there are a large number of visas going to companies that essentially only hire only hire H-1B workers. So that you're not invoking they have to pay the level to American workers that's actually higher because they're setting the rate based on H-1B workers. That's all.
But that doesn't make any sense with respect, John, because if you're setting the wage with respect to H-1B workers, but the prevailing wage in the community is higher, you're going to have a higher prevailing wage, so you're going to have to pay them prevailing wage versus what you're saying. Basically, that if there's H-1B workers and they're the total pool of employees, then that's going to become the prevailing wage, and then that's fine, or that's going to become the actual wage. I think is what you were sort of saying. That might be true, but in that case, the actual wage, if it's too low, is going to have to be pumped up to the prevailing wage, so that becomes the required wage. So that theory falls apart when you think it through.
No, it doesn't. If you go up there and look at a case like these companies, someone like Infosys, the large companies that hire thousands of H-1B workers each year, someone like Infosys is nearly 5,000 H-1B workers each year, they put out slews of labor condition applications at level 1 wages nearly exclusively. And so they don't have, since they're only hiring H-1B workers, they don't have to pay the higher of, they only have to pay the prevailing wage under the H-1B system at the level 1 wage because they don't have American workers who are making more in the same position.
Oh, that doesn't make any sense.
So I think that we'll be able to return to the disagreement about this point with regards to the next question. So if I might be able to invoke my moderator's privilege here to share the next question, then perhaps we can continue the dialectic around these past points in that context. I'm grateful for the participation of all the participants on the plenary. So thank you for bearing with us through the challenging complexities here, because I realize that there are a lot of things to understand about the immigration system to be able to respond to the questionnaires and understand the context of how these questions come up. But the question from Group 3 that I want to turn to is, can the H-1B visa process be fine-tuned to make sure that native workers have been exhausted before a company seeks out H-1Bs for that job? The second part to their question is, how can we prevent for the lost benefits of personal investment in young STEM workers who leave the U.S. after working with H-1Bs, B visas, rather than staying here and contributing to the U.S. economy? Let me read that whole question one more time. can the H-1B visa process be fine-tuned to make sure that native workers have been exhausted before a company seeks out H-1Bs for that job? Can we prevent for the lost benefits of personal investment in young STEM workers who leave the U.S. after working with H-1B visas rather than staying here and contributing to the U.S. economy?
I'm happy to go with that, Bobby, unless
Sure.
Sueta or John wants to. On the first point of that, you could do a recruitment. Right now, there is no recruitment of U.S. workers required for the H-1B program, which I think is why it's so controversial. In other programs, the labor certification program, by the way, which is the green card process, in most cases, you're required to recruit a U.S. worker at minimum requirements at prevailing wages. There's no such requirement in the H-1B program. In some of the other H programs, there is that requirement. And that's how you would fine-tune it, as you say, to make sure that there's no minimally qualified or qualified U.S. workers available for a job opportunity. And that may be a way that Congress will go. If you take a look at some of the proposals out there, in fact, bipartisan, I think Senator Durbin from one of the Gang of Eight, Democrat, was also a proponent of adding a recruitment requirement to the H-1B program. I think that's a judgment call Congress is going to have to make. As a practitioner, somebody who deals in this area, I think that it's cumbersome. These recruitment programs are very cumbersome. They take a long time, and they're not really as accurate as you think they might be, number one. Nor number two, it puts a real roadblock in the way of doing business, because as you know, business is not done through bureaucracy. Business is done to serve the client and fast. And so, I think it's a difficult question, but it's a legitimate question, the recruitment aspect of H-1Bs. And I think it's a policy question that is going to have to be thought through carefully if we ever get to any kind of serious immigration reform. On the prevention of losing, I think your question really was a brain drain question. How do we prevent brain drain? Losing people who we've trained and having them go overseas, non-citizens who have trained in STEM provisions in the U.S. universities. It's an outstanding question. And if you take a look at the bipartisan Senate bill that was passed last year, there were provisions in there that would have made it much easier for U.S. graduates in STEM fields to get green cards. And it makes sense. Why should we train them here and then lose them? It's our technology, it's our know-how, it's our ingenuity. We ought to keep it in the United States.
Thank you, David. Would John or Sweta like to respond?
I'll say that one of the problems is we don't really know what the H-1B program is. That in theory, H-1B is a guest worker program that people are supposed to come here and go back home when they're complete, after a short period of time. And in that kind of environment, recruitment doesn't really make sense because, as Dave says, it's convoluted, and even in the green card system, it doesn't provide much protection for U.S. workers. So in this question, raises that issue, because here we have the H-1 program, which again in theory is a guest worker program where it's supposed to be only temporary, but in reality it lets people, it's become the stepping stone to a green card, and so opens the door to that question being asked, how to return these people. So I think that the larger policy question that needs to be answered is H-1B going to be a temporary program, or is it going to be an immigration program?
I would like to add something to this, and that too, that's from my own experience as an immigrant, as someone who's been on the H-1, all the possible visas that I could have potentially exploited. We see so many H-1B workers here, and this is looking at it from the point of view of these workers. They are here, they contributed to the Social Security, Medicare, pay all their taxes, and when it comes to they losing their jobs or they're getting laid out, there is no way they can get this benefit back from the system where they've paid for. They don't have unemployment. They are by law obligated to pack their bags and leave which honestly, for someone who's been here for a couple of years, has a life here, has kids in school, has an apartment, has whatever, it's really I mean, looking at it, they have made all this contribution to the economy, they've made all this contribution to the system, and now there is no way for them to benefit from it, or at least recover what they've contributed. So I think this is kind of a fair point, and it makes you think about what they stand to lose when they lose their status.
Thank you. I appreciate the perspectives of all three of you on that point. And with that, let me return. Go ahead.
One of the things that I've called for, and it's on my blog, is a immigrant-friendly system where the immigrant knows his status when they hit the U.S. When a person immigrates to the United States, they should know whether he's going to be able to stay or whether he's going to have to come home when he hits our doors and not have to go through a bunch of gyrations.
That doesn't make any sense with respect. Immigrants know better than the three of us sitting here what they're looking at when they come here. They know. I mean, my experience, I'm sure Sweta could bear this out, is that immigrants know, especially the educated STEM graduates who are brilliant, know pretty much what they're looking at when they get here, whether it's all the gyrations. So I don't understand how that would be implemented, and it sounds like it's a sort of a call for a very rigid system that doesn't allow any changes of anything when somebody gets here. And of course, people who come to this country from overseas live their lives while they're here, and things change, and goals change, and circumstances change. So it doesn't make any sense to me to do it that way.
Well, of course, because we had a rational system, who would need an immigration lawyer to do a visa?
It does nothing to do with an immigration lawyer. An immigration lawyer would make makes money regardless because of people like you.
So look, I think that there are points to have disagreement about, and we don't need to resolve all aspects of the immigration debate in a single conversation. What I would like to do is turn to one final question from Group 3, which is, does the Senate bill reform proposal distinguish immediate family and adult family members, siblings, close parentheses, so that the adult siblings are granted visas based on economic reasons rather than family ties alone? Let me repeat that. Does the Senate bill reform proposal distinguish immediate family and adult family members, siblings, close parentheses, so that the adult siblings are granted visas based on economic reasons rather than family ties alone? Would someone like to answer that?
Honestly, I don't remember. I'd have to go back and look at the Senate bill. That's a very fine point. So I'm happy to do that and respond to that by email, but I'm not prepared to respond to it right now.
Go ahead, Sweta.
I think this, and it's been a while since I read the Senate bill. It died down, so it didn't make sense to revisit it, the dead. But I do remember that there was a level-based a point system where, depending upon the kind of contribution that you made in terms of economic and family, members were awarded points, and those point systems sort of decided on immigration benefits. So yes, there was a system that gave more recognition to economic contribution than to familial ties. Nothing happened out of it, so we are back to square one. And also, the bill eliminated the family-based criteria of adult siblings. So it did exactly what the questioner intended. It de-emphasized on adult family relationships and stressed more on the economic contribution made by the adult siblings. I don't remember the fine nuances of it, but I do remember that it did contain a provision like that.
Mm-hmm.
Well, and I believe the moderators and participants also have access in the briefing materials to a partial description that also relates to the point Sweta just made. It just identifies that the Senate bill's point system would include both economic ties, economic concerns and family ties as criteria by which individuals could earn points. But I just mentioning that for clarification. It's just in the briefing materials. But John, would you like to react to the substance of this?
Don't have anything to add.
Okay. Thank you. So with that, I'd like to say that we've had all 6 of these questions asked. I also want to say that we've had some excellent back and forth within the plenary. If I want to share the last opportunity that if there's another minute of remarks each of you would like to make any of in reaction to any of the past questions in this plenary or the remarks of your colleagues, I'm happy to share with you the opportunity to share a few more words, but we're just going to have that be no more than a minute each, because then we're going to have to allow the participants to return to their small groups and then to their lunch break.
Can I start by I have just one point to make that addresses the argument or the contention that H-1B workers are hired because they are paid less. In response to that, and I'm not assuming it or I'm not conceding the point, I would say that if really an employer has to take advantage of the program by paying less to an H-1B worker, and there are limited number of H-1B workers available, employers would actually go and outsource those jobs to third countries where wages are far less than what they would otherwise have to pay to an H-1 worker. So this is without even, assuming or conceding to that point, but if it's basic economics, and we are in a free market economy, and employers will do that, companies will do that which is cheapest and most profitable to them, then the downside of having less number of H-1B visas is simply that these jobs are going to go overseas. And we will lose, and the other side of it is that H-1Bs create a multiplier effect in the economy. Okay, for every jobs that are created by H-1 workers, there are jobs in the other sector. We call that the multiplier effect, or we it's like a complementary job. So you lose the benefit of a robust economy, you lose benefit of the growth in the economy if you just simply think that by shutting down H-1B workers, you're going to get anything out of it. So this I just wanted to across.
Thank you, Sweta. John or David, would one of you like to go next for last remarks on this plenary? Let me try first. John, would you like to go next?
I'm on my. Can you hear me there?
Yeah, now we can hear you.
Okay. Well, until a year ago, I worked for a company that had replaced its entire programming staff with H-1B workers and offshoring. And so the companies that we got to supply the replacements, all on H-1B visas, for each H-1B worker we got, we sent 6 more jobs overseas. So that's the multiplier effect, that these offshoring companies are using the H-1Bs to provide the on-site support. And so every H-1B we got, we were calculating and budgeting to get 6 more jobs sent overseas. So each H-1B represented 7 jobs lost in America.
So it sounds like that's the conclusion of what you wanted to share in response to the prior questions. So thank you, John, for that. And David, do you want to share any final remarks?
I'm just trying to think through the economics of that. I mean, you have 85,000 possible H-1B positions, but apparently a lot more jobs lost. So I don't know. I just, something's funny about the way that's put together. Look, I think the truth lies somewhere in the middle. The H-1B program is an important program for employers who cannot find U.S. workers to do certain positions. There's no question about it. There have been regulations. There have been, well, H-1B jobs are the most highly regulated visa positions in the country. They are employer specific. They are wage specific. they are place specific, location specific. They are benefit specific. The employer must keep notification to the government. The employer must keep extensive public files for years after the employee leaves or is terminated. And as Sweta pointed out, there's absolutely no incentive because it would be, when you think about $5,000 per cost per application, do the math, and you would be, it's far cheaper to place those jobs overseas or whatever. On the flip side of it, there's an important reason for that regulation, and we cannot have employers gaming the system to reduce the wages and working conditions of U.S. workers. We just, we have to protect U.S. workers first. But let's not delude ourselves into thinking that the H-1B program or immigration in general is bad for the United States. It is, there has been no history of immigration to this country that's ever had a bad economic result to it, ever. And when you look at the statistics, you look at the numbers, you look at the credible studies that are coming out now from the right of the political spectrum, so the Cato Institute, Brookings Institution on the other side, or the Center for American Progress, or the Immigration Policy Center, all of the credible, respected groups have concluded that immigration reform, including a way for the undocumented, which is not part of this discussion, but a way for the undocumented to comply with the law, will benefit the U.S. economy and will create jobs for U.S. workers and will raise wages, at least marginally, for U.S. workers, but raise nevertheless over the decades that follow. So there really is no economic argument against immigration reform. There just isn't. You can make one up. You can talk about a zero-sum game and say, well, if you hire an H-1B, then an American loses a job. And visually, that makes sense if you don't want to think about it any deeper than that. But like Sweta pointed out, there's an economic multiplier effect. And most of us Americans or U.S. workers are actually not in competition with non-citizens who come here to work. It's a bell curve. So at one end you have extremely qualified researchers, PhDs coming in from overseas. The other side of the bell curves, you have the people who are out there, picking the lettuce and making the beds in the hotels and washing dishes. Most of us are in the middle. Most of us have high school bachelor's, master's degrees. And so we're not really statistically in competition with immigrants. So we need to think this issue through very carefully and not close the door on immigration, because immigration has always been a benefit. It's what's made this country the phenomenal country that it is. And those that would close the door to the United States, their agenda is nefarious, and it's much different. So I would challenge everybody out there to really take a look at some of the serious studies on this.
Thank you, David. Thank you, John. Thank you, Sweta. I'm grateful for each of your participation on this plenary session. With that, I'd like to adjourn this Saturday morning, September 6th plenary session. For the participants, your moderators will be asking for your email addresses because they're taking attendance so that we can ensure that all of you receive your honorarium and incentives. So please return back to your small groups. We'll be then going to the lunch break, and there will then be a return to your small groups for the afternoon small group discussion and plenary. But with this, I want to say that we've had a rich discussion about this. I think that the discussion has helped answer the participants' questions, so I want to again express gratitude for all the plenary experts for taking the time today to speak with us.
Thank you, Bobby.
Thank you.
Thanks.
Thank you. Take care.